The courts, the judges, the sheriffs, the police, the state troopers have all been committing a crime by arresting people for not paying their court fines when they get tickets or get arrested and get a court fine, a ticket fine.
And welcome to Facts or Frauds.
Our first case this morning is People versus David Thompson. This is file number 25-1379-FH. Mr. Thompson, you can come and take a seat.
We are David Denhout on behalf of the people.
Court recognizes the defendant, Mr. David Glenn Thompson, who is now at the defense table, and he is currently representing himself in this file. Mr. Thompson, as you might recall, I just need to go over a few things the law requires me every time. Do you understand that you have the right to hire your own attorney?
That is correct.
And you understand that you have the right to have the court appoint an attorney to assist you if you cannot otherwise afford it?
That is correct.
And you'll also have the right to self-represent pursuant to the Constitution. You understand?
That is correct.
And you are electing to represent yourself. Is that correct, sir?
I am, Your Honor. Yes.
And I think you've represented yourself in this file the entire time.
Yes.
And through district court. Okay. All right. So we're here today for two things. The first is we're here today for a pretrial conference. The pretrial hearing today is just to find out where the case is going. The case probably, yes, just recently bound over to the circuit court after going through the preliminary exam phase in the district court. And I see that the felony information was filed on February 6th. And the court then subsequently issued, assume I did. Yes, a scheduling order. Or about, actually, that was done on February 5th. It looks like the information was dated February 5th, but filed on the 6th. Now we're here again today for a pretrial conference hearing. Mr. Thompson, the only thing we do at a pretrial conference hearing is just to find out where the case is going. If there is a resolution of any kind, you guys can tell me. If not, then I'm going to ask if there are some other, I'm going to ask a couple other questions. The first thing here is, see that the defendant is pending charges, and I didn't say what they were. Looks like there are 2 counts for a possession of a controlled substance. All right. Mr. Thompson, is there any resolution between this case, I'm sorry, in this case, as far as you know?
Your Honor, I believe there is.
Okay. Well, hold on. I just got to ask the other party first, because a resolution means an agreement. Mr. Denhouten, are you aware of any pretrial agreement?
I'm aware of that.
All right, thank you. That just lets me know that I've checked off that block. What do you think is the nature of the resolution then?
Your Honor, I made a deposit with the ex parte hearing regarding another matter, equity taking jurisdiction to avoid a multiplicity of suits, putting up consideration for full accord and satisfaction and settlement and closure. To my knowledge, from what I understand, it includes all matters and all liabilities related. Now, I did realize that I should have directed the clerk to deposit that in accordance with the Judicial Act revised in 1961, Act 236, under Section 600.576, depositing funds, stocks, or securities with the court clerk pursuant to court order is discharged from further liability. And in that matter, I was the payer, so I did that. I'm still trying to make sure all of this gets settled and closure in honor.
Oh, okay.
That would be another one of those envelopes that you.
Yeah. I understand. Okay.
If there's any other instructions or my duty that I'm aware of, but I'm willing to correct my mistakes.
Okay. Let's take a quick look here. And you were giving me a reference to the Judicature Act, and I know it's 600, and you referenced the
576, Your Honor.
Okay, and how do you think deposit? What did specifically again? Did you deposit?
A certificate of security.
Okay, and so what security was it that you tendered?
That was consideration
Or
for any outstanding liabilities, Your Honor.
okay, so your deposit of this certificate of security applies to how much was it for?
That it has been unassessed and unknown at this time, which is what I'm seeking further from the court assistance in.
All right, so and you think that somehow takes care of this particular file?
Due to the fact that where there's a conflict and variation in the law between common law and equity, Your Honor, equity shall prevail, and equity takes multiple jurisdiction to avoid a multiplicity of suits.
All right, so are you charged with the possession of controlled substances in more than one case?
No, Your Honor, that case, I was a payer, which falls into this with the 600-576. And to my knowledge, a trust running in the background deserves to be heard in equity.
So in this particular file, you don't owe anything.
My knowledge, I do not. I have
No, so
my knowledge, I am free and clear of liability, Your Honor.
No, liability is a different word. Liability doesn't apply here yet, right? There's no judgment that says you owe anybody money, so there's no liability.
Thank you for correcting me.
Yeah. Now, the question here is there a resolution to the case? Filing whatever you think you filed doesn't resolve this particular case.
I understand, Your Honor.
Okay.
In equity, I thought that they took jurisdiction to avoid multiplicity of suits. So
No, multiplicity is something different. Multiplicity is generally used if you've been charged with the same act more than once, or if you've been tried more than once, then that becomes double jeopardy. Multiplicity is something entirely different. Unless you're telling me you've been convicted of the same offense already before, which I know the answer is no.
I have not.
It's okay.
May,
So, I'm sorry, sir, I cut you off.
I do have evidence that I did deposit with the prosecutor's office of potential resolution.
Okay, so you made an offer to the prosecutor to resolve the case?
Yes, Your Honor, and I've got the
Okay.
card receipt.
That's okay. And so what happens here is I'm just the manager of this small version of Tiger Stadium. I always use Tiger Stadium. By the way, I don't even watch baseball. But anyways, this is my little Tiger Stadium. All I need to know is that somewhere in the future, and the date is currently on a piece of paper, looks like that is May 8th, May 6th. May 6th, we've got a game. It is the Tigers. That's his home stadium. So we'll say that's Mr. Denhound versus the Twins. That's Mr. By the way, I like Minnesota. That's fine. But all I need to know is, are we playing baseball on May 6th? If the answer is either yes or no, we're going to get two bites of that apple. Today's the first one. The second one comes at the final pretrial conference. So today, do I keep the game currently scheduled, People versus Thompson, set for May 6th? That is all I'm here to do. Now, if you and Mr. Thompson or Mr. Denhound reach an agreement, that's between you guys. I don't care what you guys deal with right outside. There's nothing to do with me. Mr. Denhound says they don't have an agreement, which means your offer has been, at least at this point in time, rejected. So now the next question here is, so that means we don't have a resolution today. I don't know. I don't understand necessarily the theory of Mr. Thompson resting on the statute that he referred to. This has nothing to do with liability, because so far it doesn't end the case. You can't pay off a fine until I order a fine. So therefore, the next question I have is, and I know that Mr. Thompson is currently on bond, so we don't have any issues there right now yet. I know there's a bond petition. The next question here is, have you gotten all the evidence, the discovery in the case, like the police report, any
I'm not
body?
sure.
Yeah,
Sorry.
it's okay. It's okay.
I'm not sure that I have it in total.
All right. So the best thing you can do is you can look at the police report, and if, for instance, it says, well, hold on. Have you received a copy of the police report?
I believe I do have one, Your Honor.
Have you received, it should be a lab report from the Department of State Police, the Forensic Crime Lab?
I'm not sure if I've got that yet.
Mr. Denham, has there been a crime lab report yet? Sometimes they're running behind. Nothing works like it does on television.
Your Honor, it has been submitted, but I don't believe we have a copy of it.
All right, so that means I turn over here and I'm just gonna say on my discovery issue, still,
Your Honor, I stand corrected. I do have a copy of it.
never mind, I don't have to write that down. The next is was there a prelim?
There was, Your Honor.
Okay, let's make sure that I ordered the prelim transcript.
January 3rd.
All right, thank you. Let me take a quick look here.
There is audio and video that has been submitted as well.
Okay.
He doesn't have a copy. I'm happy to send another copy.
All right, so I see that the transcript has been ordered by my office. The transcript of the prelim will be prepared and issued to both the prosecutor and to the defendant. Now, the next question would be, I'm sorry, if you have received those. You say you think you have, so I'm just going to tell you what you can do is look at the police report. And typically on the last page or two, it will report whatever exhibits they may have collected. Let's say, for example, this was well, I don't use an example, let's just use the charges. If there was some kind of baggie, that will be put into evidence. That'll be listed on there. You'll get the baggie. You'll get the test of that baggie. Now, you should also be able to get the chain of custody, which should generally come. So you just want to make sure that there's the chain of custody. Now, if the defense chooses ever to have a substance retested, it can ask for that, but it pays for it you would pay for it on your own. You'd have to find a lab, and then you'd have to come and have me give an order that says, hey, police agency, send it to that lab. So things like that. So you can ask questions about discovery. But so far right now, it seems like you have it. But again, if you look at that police report, look at the last 2 pages, it will list all the exhibits, and you're going to want to make sure you've got those exhibits. And typically there's some kind of body camera. Now, by the way, unlike what they show on television, not every body camera works all the time. Not every body camera gets digitally downloaded for some reason. I don't know why, but you just can find out that information. And sometimes, by the way, they're muffled. Good luck figuring that out. All right. So we don't have a resolution. We don't have any discovery issues. The next question is do we have any motions? Now, Mr. Thompson, inside my schedule order, I said, if you have any motions, such as a motion to suppress, you can raise it within 30 days of the transcript. So if the transcript gets provided to you, and let's just say for a random choice, March 15th, you have until April 15th to raise a motion, like a motion to suppress. Okay. Now that I've covered all that, now let's turn to this last question here. The next question here is, Mr. Thompson, looks like on February 19th, the prosecutor filed a petition asking to show cause. Now, basically alleging that there was some kind of bond violation. Particularly in this instance, the bond violation is that you allegedly failed to appear for a drug test on February 9th of 2025, and then February 16th, 2025. Now, the prosecutor could have asked for a bench warrant. He didn't do so, which is pretty common in this kind of a situation. I can tell you that either party or the court can ask to review someone's bond, and there isn't a right to a trial. There is no jury. There's no proof beyond a reasonable doubt. It's just that the court looks at it and gets to determine whether or not that's a violation. And then, if so, what should I do? Should I revoke bond? Should I remand the defendant into custody? Should I modify the bond? Or should I just wag my finger if they don't do that again? Now, do we want to have a hearing on that? Do you want to have a hearing? And by the way, well, hold on. Miss Dean Stark joins us today, also via Zoom from the Wexford Missaukee Community Corrections Program. Miss Stark, are you here for this one?
Yes.
I just want to ask you this question. Have there been any other alleged violations?
Two violations on the 9th and the 16th for no shows.
All right, but nothing since then?
No.
All right, thank you. All right. Has he shown up at all for any testing?
He has.
All right. Any I assume they've all been negative?
Just positive for THC.
All right, and that probably wasn't listed. Okay. All right. And by the way, Mr. Thompson, if you admit to failing to show up for those two tests, I'm just going to go with the finger wag. And say, don't do that again. Make sure you show up. Okay. Is it true you failed to appear for those two tests?
By mistake, I did, Your Honor.
Okay.
I apologize on behalf of the court.
As long as you've been going to testing and you've been, and it just was on a couple different events. I will note they appear to both be on a Sunday. So I'm just going to say, make sure you don't. The court finds that there's been a bond violation, but the court is not going to revoke, modify the bond. I'm just going to do the finger wag. There we go. All right. Yes, sir. Anything else?
I wish to express gratitude, and I appreciate the court in its leniency. And I also want to let the court know that every day of my life is getting better.
I'm glad to hear that, Mr. Thompson.
I appreciate the opportunity to improve.
No problem. And I don't mind discussing the questions you bring up. That is perfectly all right. Mr. Denhouten, anything else today?
No.
And I'm sorry, Mr. Denhouten, I should have let you argue if you wanted me to revoke bond. I failed to do that. That was
I would not have argued against it, Your Honor. As the court notes, I initially requested a show cause.
I got you. And I'm sorry. I expected you to just to say that. And so unfortunately, I skipped over you and that wasn't polite. All right. Thank you very much. This case will continue to next be set on the docket for a final pretrial conference. All right. Thank you all very much. We are adjourned.
You can't fix stupid.
And thanks for hanging out with us on Facts or Frauds. Make sure you hit the thumbs up button, you subscribe, and ring that bell. Also, leave a comment in the comment section. Tell me what you think.
And a huge thank you to all of our Facts or Frauds channel members.
And if you're still hanging out, thank you. I appreciate you all. Make sure you hit the thumbs up button, subscribe, and ring that bell. Also, leave a comment in the comment section. Tell me what you think. Till next time, I'll see you soon.